All rise. This court is now in session. The Honorable J. Michael Hagan presiding.
Please be seated. Good evening. Good evening. Good evening. This is a fun evening. You're allowed to speak. And welcome to the Dauphin County Courthouse for this very auspicious competition. I understand you've been spoken to generally, so I'm not going to be too redundant at this point. Is prosecution ready to proceed?
Yes, Your Honor.
Defense ready to proceed?
Yes, Your Honor. Drugs, greed, and incompetence can kill. Individually, each one of these can be deadly. But in this case, we have all three. Dr. Schaefer, the defendant, was greed-driven and acted incompetently by administering and prescribing medication before having all the facts. May it please the court, opposing counsel, and ladies and gentlemen of the jury, my name is Alexis Forsythe, and I, along with my co-counsel, represent the Commonwealth in today's case. What you're about to hear is about the tragic death of a local legend, Hadley McAdoo, also known as Coach. Her death was caused by the greed and incompetence of Dr. Schaefer. We are here today because the defendant failed Hadley McAdoo when she needed her doctor the most. And you, ladies and gentlemen, are here to see that justice is done. The Commonwealth charges Dr. Ray Schaefer with the felony of drug delivery resulting in death. A person is guilty of this crime if he or she administers or prescribes medication other than in good faith. The defendant is guilty because the defendant failed to act in good faith while administering hydromorphone and oxycodone to Hadley McAdoo on December 16, 2016. So, what is good faith? Good faith is defined to include faithfulness to one's duty or obligation and observance of reasonable standards within a profession. The evidence will show that the defendant failed to act in good faith. Now, how do we know that? You will learn that in the beginning, the defendant strived to avoid using opioids unless absolutely necessary. Yet, when the clinic went bankrupt, the defendant reopened and switched to an opioid-driven practice, handing out prescriptions like candy. The clinic's rates of prescribing climbed from 13% to over 80%, almost twice the national average, and the defendant raked in the cash. These practices attracted hundreds of new patients, including Hadley McAdoo. McAdoo was automatically given a prescription for opioids and had it filled multiple times without the defendant ever checking a statewide prescription drug monitoring program, also known as the PDMP, to confirm what medication she was on. And the defendant never did a single urine test, which would have disclosed drugs in her system. Now, these two precautions are guidelines set forth by the Centers for Disease Control and Prevention, which established the standard of care for the use and prescription of opioids. These two guidelines, along with many others, were violated during the care and treatment of Hadley McAdoo. Today, the Commonwealth will present to you three witnesses. You will first hear from Ms. Fran Kelsey, who is a nurse practitioner under Dr. Schaefer. She will testify about the CDC guidelines and the standard of care that Dr. Schaefer simply ignored. Now, Dr. Schaefer might try and blame Nurse Kelsey for the missing information. However, it was Dr. Schaefer's duty to obtain this information before proceeding. The second witness we will call today is Mr. J.J. Teva. Mr. Teva was a former friend of Hadley McAdoo, and he will testify on the actions and mindset of Dr. Schaefer in regards to Coach. Our third and final witness today will be Ms. Royal Copeland, who is a diversion investigator from the Drug Enforcement Administration. She will testify that the defendant's rates of prescribing were abnormally high, and that the defendant prescribed drugs for improper purposes. Now, the burden of proof in this case is proof beyond a reasonable doubt. However, it is not proof beyond all possible doubt, or to a mathematical certainty. Doubts based on conjecture, speculation, and hunch are not reasonable doubts. We, the Commonwealth, will prove to you beyond a reasonable doubt that the defendant failed to act in good faith, because one stroke of a keyboard or a single urine test could have saved Hadley McAdoo's life. Now, ladies and gentlemen, ask yourselves, would you want your doctor, who is about to prescribe you potentially deadly drugs, to take the reasonable steps to avoid fatal interaction? The evidence will show that the defendant did not have this critical information before she injected Hadley McAdoo. And that drug became a lethal cocktail when mixed with what McAdoo was already on. The defendant's actions were greed-driven, unprofessional, and dangerous. These standards of care are in place for a reason, because if Dr. Schaefer had complied, Coach would be alive. At the end of this trial, my co-counsel, Ava Smith, will ask you to return with the only verdict consistent with the facts: guilty. Thank you.
Defense wish to open at this point.
Yes, Your Honor.
May I proceed? May it please the court, opposing counsel, and ladies and gentlemen of the jury. Recommendation versus requirement. Getting 8 to 10 hours of sleep every night. Eating 7 servings of fruits and vegetables a day. Vigorous exercise 7 days a week, 60 minutes a day. What all of these have in common is that they are recommendations, but not requirements. And how many of us can say we follow all of these recommendations? Tonight we are here because Coach Hadley McAdoo, a former patient of Dr. Ray Schaefer, sadly passed away from an overdose. This was a tragic incident, but to blame this incident entirely on Dr. Schaefer would be an injustice, which is why I, Ivy Snyder, along with my co-counsel, represent the defendant, Dr. Ray Schaefer, and are here to shed light on some of the crucial factors that led to Coach's death. Now tonight, the prosecution has the burden of proof in this case. They must prove beyond a reasonable doubt that 1, Dr. Schaefer was acting in bad faith while treating Coach McAdoo, or 2, that a responsible segment of the medical profession would disagree with Dr. Schaefer's actions. Beyond a reasonable doubt means that at the conclusion of tonight's trial, if you have questions or concerns, or if pieces of the puzzle are not fitting together, the prosecution has not met their burden. Members of the jury, this is not a malpractice suit. You're deciding whether or not Dr. Schaefer is criminally responsible for killing Coach McAdoo. However, the prosecution will not meet this burden. You will learn tonight that Dr. Schaefer followed the law. The prosecution's whole case is about the CDC guidelines. But we will show that not only were these guidelines completely not required by law, but that Dr. Schaefer followed all but one of them. Dr. Schaefer obeyed the law and was acting responsibly. You will also learn that Coach McAdoo liked to doctor shop. She went to 3 different doctors, she got 3 different prescriptions, and ultimately, it was the interaction between these drugs that ended Coach McAdoo's life. Now, opposing counsel, Ms. Forsythe, went before you today and told you that drugs can kill. Greed and incompetence can kill. Well, let's break those down. You will learn that there is absolutely 0 physical evidence in this case showing that Dr. Schaefer was greedy or incompetent. Is it incompetent to follow all but one of the recommendations for being a good doctor? You will also learn that in this case, it was not the drugs that killed Hadley McAdoo. Addiction killed Hadley McAdoo. Coach was suffering from a condition called phantom pain, a very real pain in which the source could not be located. On the day that Coach died, she came into the office in excruciating pain, screaming, crying, pulling her own hair out, could hardly form a sentence. With the severity and urgency of this emergency situation, Dr. Schaefer had to make a split-second decision to alleviate her patient's suffering and save her patient's life. And that is exactly what Dr. Schaefer did. Now, earlier I went before you and told you about the difference between a recommendation and a requirement. We, the defense, ask that throughout this trial, you keep that in mind as the prosecution attempts to make Dr. Schaefer their scapegoat. We, the defense, submit to you that Dr. Schaefer acted in good faith and was a responsible doctor. Because of this, we ask that you return a verdict of not guilty. Thank you.
Prosecution may call your first witness.
Yes, Your Honor. The Commonwealth calls Ms. Fran Kelsey to the stand. Permission to proceed. Ms. Kelsey, would you please introduce yourself to the court?
Hello, my name is Fran Kelsey, and I was an employee under Dr. Schaefer at the Painaway Clinic.
And what was your role at Painaway?
I was the office administrator as well as the nurse practitioner. As the nurse practitioner, I didn't have the certifications to prescribe controlled substances. Only Dr. Schaefer could do that. That's the main reason why she had to oversee everything I did at the clinic. Because in the end, the nurse practitioners aren't the ultimate decision makers, the doctors are.
And how was business at Painaway while you were there?
In the beginning, business was really well. We had a steady flow of patients who were attracted to Dr. Schaefer's practice of Eastern medicine along with positive psychology.
And what is Eastern medicine?
In Dr. Schaefer's clinic, this meant that he mainly relied on acupuncture and lidocaine and rarely used opioids.
And how did the business evolve into what it is today?
In 2012, a natural disaster destroyed the clinic, and due to Schaefer's lack of insurance, he was forced to close down the clinic and file for bankruptcy. We reopened about 6 months later, but a lot had changed.
And what changed?
Well, Dr. Schaefer wasn't focusing on Eastern medicine anymore.
Objection, Your Honor. Pursuant to Rule 602, this is speculation into the mindset of Dr. Schaefer and how his focus shifted.
Your Honor, if I may, this is not speculation because it is the rationally based perception of my witness. This witness worked closely with Dr. Schaefer every single day.
May I be heard, Your Honor? If this is the rationally based perception of this witness, I ask that she lay the foundation for her perceptions and focus on what she observed rather than drawing conclusions about Dr. Schaefer's shift in mindset.
Your Honor, if I may, this question does lay the foundation to show the change that this witness observed.
I think the objection is not that she observed the change, but what she did observe that leads her to conclude there was a change. So I think the objection's well taken, but I think reframing the question solved the problem.
What did you observe that changed in Dr. Schaefer's practice?
Dr. Schaefer began routinely prescribing narcotic painkillers. Also, patients were being rushed to their visit and they started paying in cash.
Now I'd like to direct your attention to Hadley McAdoo. What can you tell me about her first visit?
Hadley McAdoo, whom we all called Coach, first came into the clinic complaining that she couldn't lift her arm above her head without experiencing a shooting
Objection,
pain.
Your Honor. The statements of Hadley McAdoo are hearsay pursuant to a related one.
Your Honor, this is not hearsay because it is not being offered for the truth of the matter asserted, but for the effect on the listener.
The effect on what listener?
The effect on the witness. This caused the witness to tap Hadley McAdoo onto the end of the day.
Sorry, did you, your testimony that the coach said things to you?
Yes.
Well then, Your Honor, I ask that the foundation be laid as to why this is going for the truth of the matter, not going for the truth of the matter, but for the effect of the listener.
If I may, this witness is testifying that Hadley McAdoo called her, and this is what she told her on the phone call, and this is why she scheduled her at the end of the day, and this patient came in to be seen.
Your Honor, this is going for the truth of the pain of Hadley McAdoo, so I believe it is going for the truth of the matter.
Well, the question is, why did you schedule her at the end of the day?
The question is, can Ms. Kelsey tell me about this patient's first visit? And this question sets up why this patient came to the clinic, because she called and because Ms. Kelsey scheduled her.
Okay, I'm going to allow it as to what the patient said relevant to the scheduling that you did.
Ms. Kelsey, can you tell me about Hadley McAdoo's first visit?
Yes, Hadley McAdoo first came to the clinic complaining that she couldn't lift her arm above her head without experiencing a shooting pain.
And how did Dr. Schaefer treat Coach?
Instead of suggesting acupuncture, he instantly wrote a prescription for hundreds of doses of oxycodone.
Objection, Your Honor. This is misleading the jury. Dr. Schaefer prescribed hundreds of doses over the almost 3 years that Hadley McAdoo was a patient. This witness's statement suggests that she instantly prescribed 100 doses of narcotics in their first meeting.
That's what she said.
Yes, that would be incorrect because
Why?
the doses were spread out over almost 3 years. This was not a one-time
Okay,
incident.
well, you can develop that on cross-examination if
Yes,
you
sir.
wish. That's what happens. Okay.
And how did Dr. Schaefer treat Coach?
He instantly wrote a prescription for hundreds of doses of oxycodone, and he claimed it was for a placebo treatment. But any opioid, let alone hundreds of doses of a strong opioid, is way too much for a placebo effect.
And did this solve Hadley McAdoo's problem?
From that point on, Hadley became a regular patient at our clinic, constantly coming in to refill her prescriptions.
And what happened on December 16, 2016?
December 16, 2016 is a day that I'll never forget. Coach called the clinic in a panic, claiming that she couldn't handle the pain anymore. So I tacked her on at the end of the day.
And how was Coach when she came into the clinic?
She was shaking and sweat was dripping from her forehead. I quickly wrote down her vitals and a short history in the intake log. Her heart rate, respiration rate, and blood pressure was all elevated. It seemed to me as if she was going through withdrawal. As I was in the process of checking the PDMP, Schaefer suddenly burst out, called Coach into the room, and told me to take a break.
And how did you respond to this?
I hadn't taken a break in the entire time I'd worked there. Something felt wrong. So when Schaefer finished, I checked the patient monitoring system.
And what did you notice?
I noticed that Schaefer had increased her oral prescription rate as well as given her the single greatest dosage of hydromorphone ever prescribed in our clinic.
And did you ever finish checking the PDMP?
Not
Objection, Your
a chance.
Honor. The previous question and this question go to an exhibit that has not yet been entered into evidence, I ask that opposing counsel enter this exhibit before they question the witness about it.
Why do they need an exhibit?
Because they are referencing information directly from the exhibit without presenting it to the court.
I'm gonna, go ahead.
Your Honor, permission to approach the witness. Let the record reflect that I'm showing opposing counsel a copy of what has been previously marked as Exhibits 6 and 7. Would you like a copy? Yes, please. Your Honor, would you like a copy?
I have a copy, thank you.
Can you identify this document?
This is the Center for Disease Control, also known as the CDC's guidelines for prescribing opioids for chronic pain. This document sets the accepted medical practice for prescribing opioids.
Your Honor, at this time, I would like to enter Exhibits 6 and 7 into evidence.
6 is,
6 is the Centers for Disease Control and Prevention recommendations, and 7 is also those recommendations.
is this redundant? Is there a difference between the two?
Yes, one is for clinicians, one is for patients.
Thank you.
Yes, Your Honor. The defense objects on the grounds of hearsay.
Hearsay is,
An out-of-court statement being used for the truth of the matter asserted.
what truth are they asserting with these?
All of the information contained in these documents is hearsay.
Your Honor, if I may, according to the mock trial rules of evidence, Rule 803 states that this document is an exception to hearsay, as it is a public record.
May I be heard, Your Honor? No foundation has been laid that Fran Kelsey has ever seen this document, and pursuant to Rule 4.4, that means it is inadmissible. She has never seen this document before, and therefore cannot testify to its contents.
I thought you had a copy of it,
I do have a copy, Your Honor.
and your client never saw it?
The witness on the stand has never
And the
seen
witness
this.
never saw it?
Your Honor, if I may, this document is for clinicians, and it is to be used by all clinicians, and she is a nurse practitioner, therefore a clinician herself.
Ever see that before?
Yes.
I'll allow it, go ahead.
May I publish to the jury?
You may.
Now, with respect to Coach, how did Dr. Schaefer's actions compare with these CDC recommendations and guidelines?
As far as I know, Schaefer failed to follow these guidelines on multiple occasions.
Objection, Your Honor. No foundation has been laid to Dr. Schaefer's actions or how that would relate to the contents of this document.
I think the question was,
The question was how the actions of Dr. Schaefer compare to the contents of this document, which have not yet been testified to or brought into evidence, and therefore it is there is a lack of foundation between her answer.
Your Honor, if I may, this question serves to lay this foundation, as the very question is, how did Dr. Schaefer's actions compare with these guidelines? So that lays the foundation for Dr. Schaefer's both actions and how they relate to the guidelines.
May I be heard, Your Honor? I would also object on the grounds of an improper opinion. This is just a nurse practitioner. She cannot testify to the legality and relation between these actions, as she has no legal background to testify to the CDC guidelines.
I think the question is, how did the actions she observed compare to the guidelines,
Yes, Your Honor.
which I might be able to testify to, and that's a scary thought. So we're going to allow the testimony.
In regards to Coach, how did Dr. Schaefer's actions compare to these CDC guidelines and recommendations?
Dr. Schaefer failed to follow these guidelines on multiple occasions. On page 3, under Guideline 5, it states that clinicians should use the lowest effective dosage when prescribing opioids. Dr. Schaefer prescribed Coach with the single greatest dosage of narcotics ever given in our clinic.
And were there any others?
On page 4, under guideline 9, it states that clinicians should review PDMP data when starting opioid therapy for chronic pain and periodically during opioid therapy for chronic pain, ranging from every prescription to every 3 months. Dr. Schaefer, as far as I know, Dr. Schaefer never checked the PDMP for Coach.
Can you look at guideline 10? How did Dr. Schaefer's actions compare with this?
Guideline 10 states that clinicians should also apply urine drug testing at least annually. Dr. Schaefer never used urine drug testing for any of his patients, let alone Coach.
Were there any others that are applicable?
Guideline 11 states that clinicians should avoid prescribing opioid pain medication and benzodiazepines concurrently whenever possible.
And how did Dr. Schaefer treat Coach?
Dr. Schaefer prescribed Coach with hydromorphone, which reacted with the benzodiazepine she was already taking and led to her death.
And how do you know that?
I didn't know that night, but I found out Coach died the night of, and the next day I went into the clinic and checked the PDMP, and I noticed that Coach was taking a heavy dosage of Xanax, a benzodiazepine medication. Taking hydromorphone and Xanax concurrently is a deadly combination and is directly contrary to Guideline 11 on the CDC guidelines.
And how did you react to Coach's death?
I was devastated. There's no doubt in my mind that if Schaefer would have followed these guidelines, that Coach would still be alive
Objection,
today.
Your Honor. Pursuant to Rule 602, this is speculation.
Your Honor, this is not speculation because it is the rationally based perception of the witness, as she both worked alongside Dr. Schaefer and is aware of the CDC guidelines and what is on the PDMP.
But it is her opinion that you're asking for, or that her answer was.
Yes.
We'll sustain the objection.
Your Honor, at this time, I would like to read stipulation 8 into the record.
There are no objections.
Consistent with the findings of the medical examiner of Laurel County following an autopsy, Hadley McAdoo's respiratory arrest was caused by an adverse interaction between the opioids administered and prescribed by Dr. Ray Schaefer and alprazolam prescribed by Margaret Hamburg on November 27, 2016, under its trade name Xanax. No further questions, Your Honor.
May I cross-examine?
Yes, Your Honor. On direct examination, you said that you were familiar with the CDC guidelines, right?
Yes, as a clinician, I review the CDC guidelines. Excuse me.
Your Honor, at this time I'd like to approach the witness with her sworn affidavit.